Hi, all. I'm Cullen Haynes, and this is Law Live. Welcome to episode 3, and thank you for tuning in. My next guest is an absolute powerhouse in her own right. Recently took out Mediator of the Year for 2022 at the Australian Law Awards here in Sydney. I had the very big privilege of meeting her just a couple of weeks ago, which was fantastic. Has accolades up the yin yang and is both a lawyer and negotiator and trainer. If you'd please welcome Nicole Davidson from Nicole Davidson Negotiation. Nicole, how are you today?
I am very well, Cullen, and delighted to be here chatting to you as well.
Thank you so much. And tell us what is happening post award winning of that Mediator of the Year in your circle of influence. What has been happening since then?
Look, I was actually really blown away by the amount of support that I received when I posted that on LinkedIn. So it's been really lovely, and there's people I've caught up with that I haven't spoken to a while, but it's been a nice reason for them to reach out. So it's been really lovely, and getting back into the work. So the glamour of it all dies away quite quickly, I have to say.
Oh my goodness. But it is nice to get those accolades. And I believe in previous years, it wasn't something that they focused on in the Law Awards, especially I think it's now starting to be more appreciated mediation as we move towards a more, hopefully, collaborative environment.
Yeah, look, I hope so. And certainly, as I understand it, this was the very first year that the Lawyers Weekly Australian Law Awards have had a category for Mediator of the Year. Last year, when I saw all the categories, I actually reached out and said, have you thought about mediation? It's kind of important. So I'm not sure if that contributed to this year's category or not. But I think it really is an important part of the legal landscape these days. And I think clients are demanding different things from what they've traditionally expected from lawyers. And I think getting faster results through processes like mediation is a really important part of that.
Yeah, and that's definitely something I want to talk about, mediation itself. But before we get into that, lawyers and especially young lawyers coming out of the unis are taught to be technically competent. They don't really focus much. Business is another thing. Nothing's taught on business, but negotiation styles, human behavior. Would you think that needs a bit of a focus, and we should shine a light more on that before we focus everything on technicalities and whatnot?
I think there's so many things that are involved in that question, because I think you're right. I mean, there are now subjects where students can study negotiation, learn a bit about ADR. Generally, they're fairly short, so it might be a semester-long unit or even a compressed 5-day unit. I guess there's a deeper question as to what is the role of universities. And, traditionally the universities have been there to teach knowledge. And it's then places like the workplace or things like College of Law that have that responsibility for teaching skills. What I think is happening is people are putting more and more expectations on the unis so that students come out work ready. And if they're going to come out work ready, I think they need to therefore be taught those negotiation skills.
And do you think there's, I know putting you on the spot here, there's some easy wins for people, like, I guess, the top 1 or 2 points that people should know, lawyers especially, in their dealings? Like, what's something that they can do? I guess giving you a good thing to chat on, we talked about how many lawyers will look at the emails and go, oh, I don't want to talk to that lawyer. They seem very aggressive. But then they meet them in person. They're not really like that.
Yeah, look, I think one of the issues with negotiation generally across the legal profession is that so much of it is just done with backwards and forwards emails. You can be a keyboard warrior. You can be a lot more hostile, even whether you intend to be hostile or whether you're just taken as hostile because the other person thinks you're hostile and therefore reads your email with a hostile voice. People tend to be more blunt. They tend to be less friendly than when you actually meet them in person. So, certainly I've seen situations when I've been mediating where the parties, the lawyers have never actually had a conversation about this dispute. It's just been backwards and forwards emails. Each of them will complain to me, oh my God, the other lawyer, they're so aggressive, they're so hostile. And I'm like, well, they're saying the same thing about you, but I better not tell you that. And ultimately, when you get them in the room together, they're very professional, they're very calm, they're very polite, and you can move forward with that dispute quite quickly.
It's unusual seeing people offline, online, and how different their persona is.
Yeah. Well, and even, even the online, I think it's just that the lack of connection that you get if you're never actually meeting somebody. And I've even found that recently with business development situations where I've met a new client or potential client, and I might have exchanged a few emails with them, maybe even had a Zoom call, but I've never met them face to face. And it's only when I sit down face to face with them that I really feel like we're developing a proper relationship. And that's when they stick in my mind and it's all locked in. And I'm like, yep, this person is now someone I know, someone I'll remember. Whereas until that happens, it's just another name. It's just another, thing. There's no real bond. And I think even for lawyers who are doing those sorts of negotiations with counterparts, particularly if it's a lawyer that they haven't met before, I think, to humanize it is a really important part of it.
I love that concept of humanizing law. And I think that is a nice segue into the Australian legal system, and we've had this conversation over coffee, is quite combative and adversarial and much different to other parts of the world where it's more collaborative. I'd love to get your take on where we are now in the Australian practice of law from that adversarial standpoint, and what we could do and what you see as a good thing in mediation to be more collaborative.
Yeah, look, it's really interesting. I mean, you're absolutely right. We've inherited from the UK our system of law. It was developed to be adversarial. It's very much about each side having to prove their case, and there's a real disincentive to sort of share information. You see from some of the tactics that various lawyers will use in litigation, it's like, we're not going to give them this. We're going to make them spend time and money serving a discovery document before we hand anything over. And unless we're forced to do it, we won't do it. There's no cooperation or collaboration. And ultimately that all comes at the cost of both clients. Other systems, obviously in Europe, you've got an inquisitorial system. It's a little bit different. I don't know that much about it. But to me, the idea of having someone who's driving the investigations, driving things along, to manage those processes works really well. Yeah. So, I think about, if you were to start today and say, hey guys, we need to develop a process for managing disputes. And, I will say that potentially the adversarial system still totally belongs in terms of criminal matters and some other matters. But if we were talking solely about business disputes, then to me, if you're taking the things that we know about conflict resolution and the way humans work and interact, and you said, let's start and build a system from scratch, it would not look like the adversarial system. I've put out some thoughts to people around what might be better for clients. And, once again, I think everything should be driven by what's good for the client. To me, instead of coming to two lawyers who are going to both will give their clients advice that are favourable to their client. And once again, there's been research done that shows if you give exactly the same file of information to different lawyers, you will get different responses to what the result might be in that case, depending on whether you've told the lawyers that they're acting for a plaintiff or a defendant. Yes. Statistically, you're always going to find that the client will find more favourably for the person that they're representing. That's just human nature as well. That's, a whole bunch of psychology going on behind that. But what it leads to is that both clients are getting probably overly optimistic estimates of their prospects of success in court. And so what they want in terms of getting to a settlement is escalated, and it makes it that much more difficult to settle. So for me, if you were to take that element out of the system, you might bring cases, rather than going straight to two adversarial lawyers, bring them to someone who is a conflict specialist. They could sit down with the parties and say, hey, let's unpack what this dispute is actually all about. What are you worried about? What are the facts that you agree on? Where are the issues where you disagree? And what is relevant? That information could be handed to one lawyer who is now not acting or biased towards either party, but can then give a neutral assessment of what they think that the case would look like if it went to trial. So you're pulling that subjective bias out of the process. And you might also need to go and brief other experts. Depending on what the case is, it might be a valuer or it might be a medical expert or something in some cases. Once you've got that independent position, that, should be completely unbiased. And of course, parties will still not like it if it doesn't go in their favour. But you can bring them back with that neutral assessment and say, right, let's sit down. Now we've got that opinion. Can we work through and allow you to settle this for yourselves, knowing a fair case of what it might look like if it goes to trial, try and work out a result. And if not, okay, then you're perhaps off to court, or perhaps you're off to arbitration, or maybe there's even a case where the person who's been assisting in that negotiation may be given power by both sides to make a binding determination. So there's a number of options that could be considered, but and a lot to work through. But I think there's definitely ways that we can give clients better outcomes.
I think that's a good point. And what would you say, because it seems that the Lawyers Weekly in particular, they've only launched Mediator of the Year this year. There'd be a lot of people that don't understand what a mediator is and what a good mediator should be. We had a good conversation, and then you said a good mediator is someone that both parties aren't happy with because it means they're doing their job. I'd love to get a quick snapshot of what a good mediator is and what they do.
Yeah, and look, I think that's a really interesting point as well. And I think, it also reminds me that the way that I mediate and the way I approach could be quite different to a lot of other commercial mediators out there, because my background is different. Most mediators have come from within that adversarial legal system. A lot of commercial mediators are also barristers, and advocacy is a skill that barristers thrive on. So there are times where you will want a mediator who is actually going to push the parties down a certain path and sort of maybe help them understand what the lawyers have already been trying to tell them about the strengths or weaknesses of their case. Maybe the lawyer's trying to get them to settle, but the client's not listening. So bringing in a sort of more legally focused, experienced lawyer who's got the gravitas that the client suddenly will listen to their advice when they haven't listened to their own lawyer can have a place. However, I think in the vast majority of cases, a mediator who can actually really help those parties negotiate for themselves will make a difference. And I think that's where my style is a bit different, because I came to mediation, but although qualified as a lawyer and having practiced, my background was in immersing myself very deeply in negotiation theory and teaching negotiation for a number of years before I transferred those skills into my mediation practice. So what I do, particularly when I get into private session with clients in the mediation, but also to a certain extent in the joint session, is I'm actually asking them all the questions that I would do if I was coaching them in a negotiation. So I'm really taking them through a strategic approach to this is what's a negotiation, what you have to think about in a negotiation. Have you thought about this? And I'm asking them all of these questions about their case to try and make sure they have thought about all the things that they need to think about before they go, yes, we should settle, or actually, no, our best outcome here is to walk away.
So it's a good mirror for the client to actually, or a good sounding board, really, and both parties can have that.
Yeah, absolutely. And I think that's it. And, once again, I try as much as possible to get the clients themselves involved in all of those conversations rather than the lawyers being the main mouthpiece in the mediation. And it's a very fine balance for me as well, because of course it's the clients that refer me in. So I have to treat my client, who's the client that refers me as the lawyer, the client that pays me as their client. And I need to keep everyone happy. So, some lawyers are a bit more resistant and they don't want their clients to speak. I had one barrister once who, when his client tried to talk to the other side, literally went, shh, don't talk.
Which anything you can say can be given in evidence.
It was quite astonishing. And of course, what it did was it created an entire sense of distrust in the other side. And from that point forward, the negotiation was actually doomed, because what the other side thought was that they were hiding something. Don't talk because there's something you're going to say that will be helpful to them. So, you get to manage these lovely challenges.
It's all about perception. It's so powerful. And what I did in terms of what you're saying in our conversations is that you are obviously very, very intelligent, but very fair. And you say, when it seems like you're being very harsh, even on your own client, you walk into the room and you'd say things like, hey, you think I'm being harsh, but just remember, in the other room, I'm being just as harsh. And it's that impartiality, I think, is important.
Absolutely. And I say to each of them, I'm the devil's advocate. My job is actually to make sure, and the way I normally say it is, my job is to make sure that if you don't get to an outcome today, that you don't regret it in 3 days, 3 weeks, or 3 months, or 3 years when this litigation is still going on. So I'm going to make you think about every possible thing as much as I can in the mediation, so that you don't have things pop up later and you go, oh, if I'd known that, I would have done it differently, if only.
Yes. And people usually, or plaintiffs usually engage you before they want to go to court, or when do you find that people are reaching out to a mediator like yourself? Like, when's the point?
Look, it's really interesting. I'm a big advocate for people trying to mediate before the dispute's gone on for too long. So I actually think mediating prior to litigating is a good idea. They won't always settle. The argument that lawyers will give, and I've heard this one before, the lawyers will say, no, we can't argue because we don't know what all the causes of action are and we don't have all of our ducks in a row. My comeback to that, or my response to that, I guess, is if you ask your clients what this dispute is about, they will absolutely know from a commercial perspective what the dispute is. So if you can actually get them in and have a commercially focused negotiation to try and resolve it, you may resolve it. And, I think the fact that we've got organisations like the Victorian Small Business Commission, which does...
Shout out to them.
Yeah, shout out to them. They're a fantastic organisation. And for small businesses, it's just a low-cost, quick way to potentially resolve your dispute. So I think they do a fabulous job. I am one of their mediators, so I will disclose that. But it's a great opportunity for small business. But we also know that over 80% of the matters that come to mediation at the VSBC are resolved without ever having to go to VCAT or to court. Now, I don't know that there's a significant difference between those types of disputes and a lot of other disputes that are out there in the commercial world that could benefit from pre-litigation mediation. Yeah. Even if they don't settle, then I think, there's a good chance that you'll be able to narrow down some of the issues that are there, which will minimise the cost of litigation. That being said, most of the mediation work that comes to me, particularly from lawyers, is where there is already litigation on foot. And the court has said, you guys have to go and mediate. So they're mediating because they have to rather than because they want to, which also provides some challenges in terms of, the number of times that people will come in and go, well, we know that this isn't going to settle. They've made their mind up before the mediation starts in some cases.
It's like a fixed mindset there. And what I would encourage people, if you people are tuning in, obviously there, Nicole, we've got Mitch Jackson Esquire watching late night from Southern California. He says, wonderful conversation.
Oh, hi, Mitch.
Yeah, Mitch is a California lawyer. So I've been a follower of his for a fair bit now. It's good. And I would suggest anyone who has any questions, keep them evergreen, put them in the comments. We'd love to hear from you. And if you've got anything more in depth with personal details, maybe reach out to Nicole directly and talk about your matter directly. But feel free to share. We're streaming on LinkedIn, Facebook, and YouTube. We love hearing your questions. I guess in terms of, the makeup of mediators, are there that many? And is there a sort of, it's a bit of cognitive dissonance in mediation? Do people tend to go with who they know rather than who is most competent? I'd love to touch that, Nicole.
Look, I think there is, and there's a certain element of, when a lawyer puts a mediator forward to their client, if the mediator doesn't do a good job, the lawyer will probably be held accountable for that, and the client will go, why? So I think that does make lawyers very conservative about who they will use. I think I may have shared this last time. I was actually told early in my mediation career, I sat down and had a coffee with a partner from a very large firm who was a disputes partner. And he said to me, Nicole, you really sound like you know what you're talking about. And I suspect you'd be a very good mediator, but we are very conservative as lawyers, and we will probably keep using who we've always used because we know they'll do a reasonable job, but we'll keep using them even if they're not very good. And he actually said that last part, which kind of floored me. We'll keep using who we've always used, even if they're not very good. And I will never forget that. So, look, I think if you look at the commercial sector, I'm becoming aware of a few more female mediators in the space.
Good.
There's not a lot of young mediators. And I think mediation is probably one of those things you have to have a little bit of grey hair to be able to do very well, but that will probably change as well. But in the commercial space, all of the names that come up regularly when I say who do you use for your mediations typically are males, and mostly, well, I should say pretty much all white males and pretty much all over 50. Now, look, once again, hopefully that will start to change. I've been talking a lot recently in social media about equitable briefing, and there is an equitable briefing policy to support women barristers. That doesn't cover women mediators at the moment unless they are barristers, and I think that was put together by the Law Council of Australia. I think there wasn't much consideration that there are actually career mediators rather than just barristers who mediate.
No, it's changing it seems like a paradigm shift is in order here, Nicole.
Look, I think I'm trying to nudge it and just get that sort of reach that tipping point.
Oh, absolutely. And you're already doing that, I think. So, and the fact that you won Mediator of the Year for 2022, it's applauding that fact. Switching gears a little bit, obviously, it's great to win the awards, but obviously there's this thing in law like imposter syndrome. We talked about it with Peppy and Lara Wentworth on our previous episode. I'd love to get your take on imposter syndrome and whether the drive for winning awards is a good thing or it can be a slippery slope that you need these things, striving and never arriving.
Look, I mean, firstly, obviously, I think imposter syndrome is, so important that we're talking about it. And, it's really interesting. I think I've probably struggled with that imposter syndrome since the very beginning of my career. And when I look back, I think a lot of the moves that I made early on were because I just felt like I didn't belong. I felt like I didn't belong. I didn't even feel like I belonged at law school. I remember my very first week in O Week at law school, and we all sat around in a group. There's about 12 of us with, I don't know, probably a third year or something as our buddy. And they went around the circle and we had to introduce ourselves. And it was all, who are you? What school did you come from? And what was your Anderson score? And, I remember going around because I was kind of at the end of the circle and it was like private school. And I'm like, yeah, I went to Blackburn High, and you could almost look
Shout out to Blackburn High. Come on.
Yeah, look, it's a great school. And 6 months down the track, I remember going and having breakfast with a group of friends, and one of them said to me, "Oh, what school did you go to?" And I said, "Oh, I was at Blackburn High." And she said, "Really? You don't look like you went to a government school."
Oh my goodness.
I've never let her forget that. So I think things like that really contributed to the fact that I wasn't sure that I belonged in the legal profession. Was I there? Was I faking it? Was I going to get found out? So I think imposter syndrome really is a big thing that we should be talking about and helping people work through. It's only really been for me in the last few years as I've got older and found other ways to sort of think about the world that my confidence has grown to a point where I go, actually, I do belong here. Having said that, I think imposter syndrome still creeps in, because when I got that award, the first thing I thought was, why would I be getting that? What have they done? So I think it's something that is consistently there. I don't know that for me, going and trying to win these awards, and because realistically, a lot of these awards are self-nominated. It's not about overcoming imposter syndrome. If anything, it actually, it doesn't change it. You still go, hang on, how did that happen? Why me? But I think the awards are a great way to put out to the world. I mean, the awards really are about presenting an image to other people about your capabilities. And I guess it's much easier to say, I won Mediator of the Year, rather than I'm an awesome mediator, you should use me. So it's almost giving that objectivity, so that if you are a bit uncomfortable tooting your own trumpet, you've got somebody else tooting the trumpet for you, and you just have to share their piece of music, if you like, if that analogy works.
No, it is toot your own horn. I say the same thing to my team, because we recently had an experience where we won the Broker of the Year Australian Law Awards, and I used the example of thank you. I used the example of Lady Gaga, because when she was filming a movie called The Star Is Born, she always told the story behind the scenes of, there can be 100 people in a room, 99 don't believe in you, but then there's that one, and she points to Bradley Cooper. But then they replay it on YouTube. She said it over and over again in interviews. You should do things like that. If you're proud of your achievements, clients don't know you're telling other clients that. Be proud and tell them, because it can mean the difference. Like you've got two mediators, one's won that award. Who are you going to go with? It's common sense. Mitch is a big fan of yours. He's saying we need more women mediators in the world. Frankly, the world would be a better place when this happens. Thank you, Mitch. He's also got another. Thank you, Mitch. He's got another question for you, and I think you'd be good at this, Nicole. He said, "Any tips for Zoom mediations? How about your thoughts, Ari? Future mediations in the metaverse, VR interactions on avatars?" Oh, that's a good question.
Oh, that scares me a little bit. Touching on Zoom mediations, I actually, if you'd asked me at the beginning of 2020 whether you could do mediations on Zoom, I would have said you had rocks in your head and it wasn't going to work. I genuinely thought that the importance of the interpersonal connection meant that mediation wouldn't work online. I've pleasantly had my opinion changed on that. And, particularly in 2020, I was very busy doing mediations with the VSBC. All of those were online. Settlement rates weren't impacted. There are definitely some benefits to mediating in person. And, for one, I enjoy it more when I'm there in person with people than I do when I'm on a screen and spend all day at home by myself, because I have a home office. But I actually found that the fact that people were remote in some cases had a lot of benefits, particularly where there was a bit of a power imbalance. And it meant that the person who had less power was generally in an environment they were feeling comfortable in. It's less stressful, particularly if your mediation is going to be held in the CBD and you're from somewhere further away. The cost of coming in and parking for the day or figuring out where you've got to go, all of those things that mean by the time you even arrive at the mediation, you might already be stressed, which is not helpful. So I think you can actually make people feel quite comfortable by doing those things remotely. It does take a little bit more skill sometimes to manage how the process goes, and you do occasionally get technical issues. But I found that that's becoming less and less because people are more used to it. The concept of avatars and VR and all of that, I just don't know why we'd need it. It's not that it won't go that way, because people are always creating things that we thought we didn't need. But it's not something I'd be pushing for at this stage. I'm quite happy in my two-dimensional mediation world, because it's not like we get up and dance around in a mediation. We're just sitting at a table looking at each other. So to me, I'm not sure whether that's something that will add value or not, but I'll wait and see. So good question, Mitch.
Good question, Mitch. He's got a laughing emoji and saying it's a new world, right? So very good points there, Nicole. I guess this is a bit left to centre, but on the same point, I went to the ABAs in Melbourne in April, and there was a barrister, or it was actually a leading judge that spoke and said, look, I'm all for the new world and virtual Zooms and things like that, but I think in that time we've actually lost respect for the environment and not dressing up. And, you got someone on the other side of the screen that's giving directions and they're looking to the side. Actually coming into the courtroom or having a more formal setting actually, puts people in another state. I'd love to know your thoughts on that. And are traditional settings like in person more beneficial to the work that you do in mediation, Nicole?
I would say probably not. And, I think once again, if I'm looking at what's the impact for the client, if you take the average client and put them into a formal courtroom setting, a lot of them will feel really uncomfortable. It's not a pleasant environment to be in. Now, even with mediations, a lot of the time for commercial mediations, I'm going in and those mediations are being held in a law office or somewhere that once again is quite structured. It's very business-like. I would be really happy to see mediations happening in much more informal settings, much more comfortable settings, because as I said, I want people to feel at home. I want them to feel comfortable and relaxed so that they're focusing just on the dispute. Now, once again, all of these things, it's horses for courses. So with some mediations, if the clients are formal and the clients like to present in a particular way, then as a mediator, I would match them. So if you want to have a mediation where we're all suited and we're formal, that's absolutely fine.
Yes.
For other people, you might go, well, actually, we're going to get a better result. They're going to feel more comfortable if we are a bit more relaxed. So we might dress down a bit. Now, I probably would never turn up in a hoodie and tracky pants. But
or smoking a vape or something like that.
You're probably never going to see me in a hoodie and tracky pants out in public. So, but I think it is about, for mediation, it doesn't have to be formal. It's got to be respectful. So you've still got to show respect. But you can do that in a whole range of ways, I think.
I love that. I love that concept. I think it's quite nouveau, and I think that it just means that more people, you'll be able to impact more people, and people will be more themselves, which is bringing back that human element you talked to at the start, which is important.
And it's interesting because I was just thinking, generally I will put a bit of effort into my appearance when I'm mediating. So I'm not going to have really casual gear on. I will, this is kind of a standard for me. I don't have a jacket, but I've made an effort to do the hair and a bit of makeup and a bit of jewelry.
You look fantastic, by the way.
Oh, thank you. But I've also got to create, as the mediator, I've got to create that sense of trust in my clients, and I need to be somebody that they believe knows their stuff and is competent and able to help them. I've also got to be really approachable. So I try and think about, how do I present that image?
Yes.
The other thing you talked about, though, was cameras. And once again, that's a real problem where you've got somebody who maybe has a laptop and you're looking up their nose, or they've got multiple screens and they're looking at a screen, but the camera's over here. It's really distracting. So once again, I can only control mine. I do try and get participants to make sure that they've gotten, a camera in the ideal place and things like that. But there's a limit to what you can do. I have put a lot of effort into my background so that I've got my screen, my camera set up. So I'm trying to look as directly as possible at others. I try to minimize what I've got on other screens, because once again, that's going to have an impact for others. So you do what you can, and, having a decent quality microphone. So I think any mediator who's mediating on Zoom, they absolutely need to be thinking about it, even if their clients aren't.
Yep, it's a good point, and I don't know if you've ever experienced it, but how do you deal with the person who's obviously taking direction from someone behind the camera? They're looking and then they answer. Do you call them out, or do you just play dumb? Well, I'd love to know what you do in those situations.
If it's in the mediation, I have an obligation to call that out, because the mediation is confidential and people will have signed a mediation agreement. So anyone who's present at the mediation should have signed a document to confirm that they're keeping it confidential. So if there's parties in the room, and it is one of the downsides of virtual mediation, is you can't 100% control that. But I will definitely, I will ask, in that case where someone's looking or doing something, I'd say, is there somebody there? Is there somebody else that we should be introduced to on the camera? And try and do it softly as I can. If it keeps going, then I'd have to take them into a private room and have a much more stern things going, I don't know that you're telling me the truth.
That's a good point. And I think that's good that you do call that out. I got two more questions, but I'll save those for bonus questions for our premium subscribers on the podcast. I'd like to ask you, when all is said and done, as a final question, how would you like to be remembered, Nicole? How would you like to be remembered?
That is such a good question. Look, it's interesting. I think my whole career, we've chatted about my lengthy career path and all the journeys that I had. And I think the one thing I was looking for the whole way is that I wanted to be making a difference. And in all the other roles that I had, I didn't feel like I was doing that. So I think now that I've found my space that I absolutely love and totally passionate about, improving the way we resolve disputes, I'd love to be remembered as somebody who's actually contributed to making systemic changes that have given clients a better experience of resolving their disputes.
That's fantastic. And I dare say, even taking it to that next level and impacting other people who want to join mediation, you've opened doors to make it possible for them to do it.
I'd love to think that too. Yeah, look, I mean, it's really difficult at the moment for somebody to make a career solely as a mediator. And I would love to see that change. So if I can contribute to that, and actually having more mediators out there in the world, perhaps, lawyers who change and move across, or people from other fields as well, that would be an amazing thing to leave behind.
Very admirable. And where can people find you? What's the easiest way to contact Nicole Davidson?
Yeah, so I've got my website, which is very easy to remember. It's nicoledavidsonnegotiation.com.au.
Nice and easy.
And LinkedIn. You can find me on LinkedIn. I'm really active on LinkedIn, so very happy to connect with anyone there. And that's, my website's got all my other contact details on it as well.
Fantastic. Well, everyone, be sure when you're watching this, and it'll be saying previously live when we end, make sure you connect. Please reach out to Nicole. And thank you again, Nicole, for joining the official part of the stream.
It's been an absolute pleasure, Cullen. Always nice to chat to you. And by the way, happy birthday for yesterday.
Oh, thank you so much. 34 years young. And I'm excited because this time next year when I have my birthday, I'll have a 1-year-old, someone that's another party, a baby that's born. So it'll be a very different experience.
Life will be very different indeed. Good luck with that.
Sure. Thanks so much there, Nicole. Appreciate it. And everyone, thank you for tuning in to another episode of Law Live. We come out Wednesdays, every Wednesdays, and you can also get this where you get your podcasts. Bye for now. Nicole, that was fantastic. And I've got 2 questions to ask you for our, premium subscribers on the podcast. How do you explain what you do? How would you explain it to a 6-year-old?
I will say I am the person who comes in when there's an argument and tries to get the people to play nicely.
I love that. As nice as possible.
As nice as possible.
Very good. That's simple enough. I love that. And I guess the last question, what advice would you give to your younger self, and when would you give yourself this advice? What age would you be?
Yeah, look, I've been thinking about that because I think there's so many pieces of advice I'd give my younger self. I think a really big one would be to worry less about what other people think about you. Try to build your confidence earlier. You're not going to be liked by everybody, but you also don't need to be liked by everybody. And just focus on doing what you are keen to do and find ways that you can keep doing that.
Fantastic. It sounds like you'd give that as early as possible, maybe when you're even 2 or 3.
Absolutely. Oh, probably high school. I'm guessing I'd probably start with that in high school.
High school, I think that's the time, right?
Yeah.
Yeah. High school's very different now than when we were in high school. I think it's much harder to be a teenager in the digital world where everything's on record.
I think there's a lot more challenges. Yeah. Absolutely. And, it's interesting. I've got 3 teenagers now, so I watch them going through that. Luckily, none of them are too into the social media, but
good.
It's the lack of face-to-face communication. My boys will sit there and game with people and they say they're catching up with their friends, but they're actually only talking to them via headphones and speakers. I'm like, that's not catching up with your friends.
No.
So it is a very different world.
Definitely. And I know some of the language and stuff that can be used on those real-time games can be quite jarring if you haven't heard it before, but they're blowing off steam, which is the most important thing.
Yeah. And look, over lockdown, it was an absolute lifesaver for them that they could socialize in that way. Whereas, we wouldn't have been able to do that if we'd had lockdowns when we were younger. And absolutely. I'm just a little bit older than you, but there was definitely none of that going on.
No, definitely not.
And you could only play Atari for so long.
Oh, how good was Atari? My goodness. Along came Atari. But Nicole, you're an absolute gem. The law world and mediation world is blessed to have you working as an advocate and for your clients. And thank you so much again for joining us today.
Thanks again, Cullen. It's been really nice chatting.
Nice chatting. All right, everyone. Have a great day. Thanks for joining Law Live.